dihormati sekalian. Terima kasih kerana sudi luangkan masa bersama kami di sesi Facebook Live bertajuk sesi Bicara Pekerja. Dan nama saya Mahira Mulyo dan saya merupakan seorang ahli pemuda PSM, pemuda Parti Sosialis dan also ahli media dan komunikasi PSM. Pada malam ini kita akan ditemani dua para panelis yang berkaliber dalam bidang undang-undang dan hal-hal kemanusiaan di Malaysia. Short introduction untuk mereka. Saudara Arul merupakan timbalan pengurusi Parti Sosialis Malaysia, manakala saudara Edmund adalah Head of Chambers dan Peguam untuk Bon Advocates. Beliau juga merupakan pengarah untuk Malaysian Centre for Constitutionalism and Human Rights, MCCHR, iaitu sebuah organisasi non-profit organisation. Okey, selamat petang saudara Arul dan Edmund dan terima kasih kerana sudi menjadi para panelis kita pada malam ini. Okay.
Terima kasih Mahira.
Okay. Sebelum kita meneruskan dengan sesi soalan kita, saya akan menceritakan secara ringkas berkenaan dengan topik yang menarik ini. Kerana topik ini dikira macam sebuah cerita ala-ala David versus Goliath lah. Para hadirin, kalau kita dapat, kita boleh letakkan pautan di link video kita, socialist.net untuk mereka baca lah. Ya? Okay, secara ringkasnya, Encik Subramaniam ni merupakan seorang pengawal keselamatan di Kedutaan Amerika Syarikat. Untuk kita dikira sebagai Park Guard lah, security guard. Beliau telah bekerja di situ selama 21 tahun, tapi pada 4 April 2008, beliau telah dipecat tanpa sebab, tanpa surat rasmi atau melalui mana-mana proses yang betul lah macam siasatan dalaman. Ya, ini mengejutkan, tapi yang lebih mengejutkan lagi ialah bagaimana panjangnya jangka masa yang diperlukan untuk kes ini berlangsung. Kes ini ditangguh selama 11 tahun kerana ada wujudnya pertikaian sama ada Kedutaan Amerika Syarikat mempunyai keistimewaan diplomatik. So dari sini saya ingin mempelawar saudara Arul untuk menyambung dan memberi info selanjutnya sebab saudara Arul merupakan salah satu pihak yang terlibat secara langsung dalam kes ini. Silakan saudara.
Terima kasih Mahira. Terima kasih juga kepada saudara Edmund Bon yang banyak membantu juga PSM dalam isu-isu kerja-kerja pro bono lah. Dan actually this case bukan 11 tahun Mahira, kes ini 13 tahun sekarang. Okay, so ya 13 tahun, seorang security guard melawan sebuah negara kuasa besar dunia Amerika Syarikat. Sebenarnya on the surface kes ini sangat simple because pada 2 April 2008 Subramaniam sakit, dia pergi ke klinik ambil cuti sakit 2 days, he got 2 days medical leave. Dia bagi kepada kedutaan dia bagi pada supervisor dia. Cuti dia 2 hari bulan dan 3 hari bulan MC. He was having fever. 4 hari bulan pagi dia dapat call, kamu telah dipecat, tak perlu lagi datang kerja. Serahkan barang-barang kamu, dipecat. Tak ada inquiry, tak ada domestic inquiry, tak ada surat warning, tak ada apa-apa, So bagi kami so what Subramaniam did is, of course he went and tanya, dia cakap, sorry, tak ada apa. So dalam undang-undang Malaysia, kalau seorang pekerja dibuang kerja, sebelum ini Subramaniam dah kerja di US Embassy 21 tahun. He's not a new worker lah. So dia kena file a case within 60 days. Pada 23 Mei, the next month, 23 Mei 2008, dia sudah file under Section 20 Industrial Relation Act lah. But then what happened, the case was never been called. Selalu bila you panggil, you hantar satu surat, dalam masa 3 minggu lah pengalaman kami Industrial Relation Department, Jabatan Perhubungan Perusahaan akan jemput kita untuk berbincang. So dia tunggu 2 tahun, tiap kali dia tanya, dia orang cakap ada masalah sikit, kena tunggu. So 2010, 2 tahun selepas itu, dia jumpa PSM. He said, I dah jumpa my lawyer has sent letter to the IRD, this case is not moving. So lepas 2 tahun, 2010 dia jumpa PSM. 1 March, then PSM was pressuring. Finally, 1 March 2011, you see 2008, now 2011 already. finally the IRD department cakap, kita sudah hantar kes ini kepada Foreign Affairs Ministry. We think we are waiting for feedback from Foreign Affairs Ministry, you know. And what IRD cakap, industrial relation, they say under the Vienna Convention, US Embassy got immunity. But tetapi kita perlu clarification. So they send the case to the Foreign Affairs Ministry. So 2011 we wrote letter, 16 months, 2012 we wrote letter, 2013 we wrote letter. There was no response from the Foreign Affairs Ministry. So finally what we did, we reported the Foreign Affairs Ministry to Biro Pengaduan Awam. We said it's inefficient, they don't know how to reply letter. So pada 24 September 2013, already 5 years after the case, we report to BPA. And then what happened, finally, protocol from the Foreign Affairs Ministry invited US Embassy for a meeting at the Foreign Affairs. So I attended the meeting with Subramaniam. At the meeting, the US people said, all our data don't have because it has been sent to Washington. We have got no records of this case, matter in Washington. So we cannot answer anything in today's meeting. So what we did, we kept following up with the US Embassy. They said they don't have any documents. So kami yang furnish semua dokumen kepada US Embassy. Chronology, surat pemberhentian, it was sacked, all the letters, we sent it to them, And then, after kita serahkan semua dokumen, tidak ada lagi follow-up meeting. So we went back to the Foreign Affairs Ministry, tanya apa lagi. Suddenly now, Foreign Affairs Ministry beritahu kepada kami, they cakap under some international thing, I cannot talk to you all. You all both, I'm sorry we called the first meeting, we made a mistake. You both of you all resolve it. I will ask the US Embassy to talk to you, So finally, we met 17 December 2014, 17 October 2014, we met the US Embassy at the US Embassy. And in that meeting, they only said, we think the termination is fair. I asked them, there is no warning letter. They said, we are not worried about all that because as far as we are concerned, it's fair. So now again, we wrote back letter to the minister now. Now we went back and saw Raghu. Raghu said, okay, let's take them to court because under the law, let's take the Ministry of Human Resource. Kita bawa Menteri Sumber Manusia ke Makhamah kerana tidak mau rujuk kes ini, So kita tulis lagi satu surat lah pada 7 Disember 2015. Okay. And then again, mereka tidak reply our letter. Finally, peguam kita, ada dua peguam sebelum itu, peguam Guldial, selepas tu Raghu, hantar lagi satu surat pada 7 Disember 2015 lah. Okay, after we send this letter, finally, then we send this letter was sent to Richard Riot. Richard Riot itu Menteri Sumber Manusia, And then finally in June 10, they had some meetings. Reconciliation meeting was called. And finally, when YB Kula came to Menteri, kita sekali lagi hantar surat kepada Kula. Mengapa kes ini tidak dirujuk? Finally, pada Julai 2018, Kula referred the case to Industrial Court. So already 10 years for the case, 60 hari itu jadi 10 tahun. But when bila case ini pergi kepada Industrial Court, what happened is the US Embassy cakap Industrial Court has no jurisdiction. So mereka argue lah, US Embassy lawan sama ini security guard like they are fighting with Iran like that, They were telling the security guard, first thing when you serve the letter, you cannot serve to the embassy. They say the Industrial Court, when they send them a notice itu harus dihantar kepada Kerajaan Amerika Syarikat. Dia cakap pihak pembela kes cannot be Kedutaan Amerika. It must be Kerajaan Amerika Syarikat. Mereka guna banyak technical terms lah. But industrial court, the Hakim industrial court cakap, all that he listen dua-dua pihak, dia cakap, he can hear the case. Dia boleh dengar case ini. So what the US government did, other than mendengar case ini, mereka bawa case ini ke mereka bawa case ini ke Mahkamah Tinggi. Sebelum itu kepada Richard Ryan, masa kita tulis surat kepada Richard Ryan, kita tulis mengatakan 2016 Jun 10 saudara Edmund Bon dia sedang menang satu case on the Australian Embassy dalam isu immunity. So we told the minister, the headlines of the newspaper said foreign this one got no immunity against, they must follow the Malaysian law, So we wrote that court judgment, kita tulis kepada Richard Ryan and told him, why are you not referring the case, you see? So when the matter went to High Court, sedihnya masa itu ada dua case di High Court lah. Satu was a Libya case. Also they lost, the worker lost. And then this case, Subramaniam lost. So finally, we lost the case. We lost the case, kita kalah case di Mahkamah Tinggi. Lepas tu kami buat appeal di Mahkamah Rayuan. Pada 3 hari bulan Februari 2021, sebulan yang bulan Februari, bulan lalu, the appeals court finally mengatakan the case can be heard in industrial court. Kita belum menang case ini tau. Dia hanya cakap case ini boleh didengar. After 13 years, baru kita have the right to be heard. Hak untuk didengar, Sama ada pembuangan kerja itu sah atau tidak sah lah. So akhirnya, we thought that is the end of it lah. Kita sudah pergi ke appeals court. Appeals court is satu court yang sangat tinggi. But what happened is pada 4 hari bulan Mac, bulan ini, US Embassy bawa security guard ini yang gajinya RM1,600, bawa dia applying for dia buat appeal di federal court lah. So sekarang ini we have got one more level to fight. Kalau mereka tidak dapat stay, mungkin nanti Edmund boleh jelaskan. Kalau mereka tak dapat stay, kalau mereka dapatkan, if we win, baru case ini akan dibawa balik ke industrial court. And for the first time, security guard ini ada hak untuk bercakap. So you look, it took so many years. Initially kita ingat kerajaan kita tak ada keyakinan untuk bawa US Embassy, to court. Finally, the minister had the guts to refer the case, and then US Embassy argue lah. So inilah cerita security guard 13 tahun masih menunggu pembelaan. Ya. Yeah.
Jadi boleh dengar pun panjang lebar, a lot of bouncing back and forth between different parties, dan hanya untuk mendapatkan peluang untuk Encik Subra untuk mempertahankan diri dia. Ya. Okay, sebelum saya memulakan dengan soalan pertama saya nak dapatkan komen daripada saudara Edmund. Kepada para hadirin sekalian, sesi ini kita bukakan untuk bahasa English dan bahasa Melayu, jadi boleh rojak-rojak. Silakan saudara.
Terima kasih PSM Mahira Aru untuk menjemput saya. Kes ini adalah kes yang penting sekarang kerana terdapat satu penghakiman oleh Mahkamah Rayuan berkenaan isu kekebalan diplomatic immunity. Kerana dalam kes yang kita menang terdahulu, Karen Chu di Mahkamah Tinggi, kita telah berhujah, saya fikir sampai 8-9 bulan. Ada hujahan lisan, hujahan bertulis, banyak kali telah masuk mahkamah, dan isunya sangat susah pada masa itu kerana Hakim Mahkamah Tinggi berdepan dengan nas undang-undang yang katanya 50-50 lah. So akhirnya saya berpendapat bahawa isu yang kami hujarkan bahawa undang-undang tidak boleh, there cannot be a right without a remedy. So hujahan yang kita telah buat akhirnya bagi kita yang kita katakan telah sway the judge, menukar atau menolong hakim untuk membuat keputusan berpihak kepada anak guam kami terhadap Australian Embassy adalah bahawa isu seseorang rakyat Malaysia tidak mempunyai apa-apa remedy, dan jika beliau tidak mempunyai apa-apa remedy di mahkamah, bermaknanya beliau tidak mempunyai apa-apa hak di bawah undang-undang yang sama. Sama ada kamu adalah seorang pekerja dengan kedutaan di Malaysia atau pekerja dengan pihak-pihak lain yang bukan kedutaan. So there is no equality of arms. There is no equality of rights. When the same act, the Labour Act, the labour laws apply to all Malaysians across the board. And the only law that appears to favour the embassies, all the embassies, adalah isu convention yang telah adalah authority convention, Vienna Convention, yang telah ditandatangani di UN oleh pihak-pihak negara-negara seperti Malaysia dan Amerika Syarikat. Logik konvensyen tersebut adalah supaya para pekerja-pekerja kedutaan, terutamanya warga asing, boleh dengan bebas membuat kerjanya sendiri di negara asing, di dalam kedutaan. Jadi ada yang orang kata kedutaan itu macam sebuah negara lain atau pulau yang lain. You cannot actually go in because that's actually the space and the grounds of a sovereign country. So the diplomatic immunity is just to make sure that they are able to perform their functions as a sovereign country allowed by the host state. So that our Malaysian embassy in America, for example, or in Australia can do their work without being stopped or without being interfered with. Itu dia maknanya kekebalan immunity. So kalau mempunyai diplomatic passport, pihak polis dalam negara tersebut tidak boleh membuat rampasan, cannot do a search, tak boleh even arrest you or go into the home or do searches and raids. Tetapi kita telah tengok bahawa kekebalan immunity ini telah terlalu luas sampai ada banyak insiden di seluruh dunia di mana kekebalan immunity ini has been abused, telah disalahgunakan. Jadi ada kes macam diplomat mengambil dadah, diplomat mabuk memandu kereta telah melanggar orang dan orang tersebut tu mati. Ada diplomat yang merogol orang. So jika kita meletakkan kekebalan immunity ini secara luas, diplomat-diplomat ini boleh membuat kesalahan-kesalahan jenayah tanpa ditangkap. And this cannot be right. So therefore, what has happened over the years is that slowly this sovereign immunity principle has slowly been limited and cut down. Criminal cases, personal. It's not part of your diplomatic job, so you can be arrested. Remember, there was a diplomat in one country, he ran the car and he killed someone, and then he ran away outside the country, and they cannot stop him. They cannot catch him again. Then the diplomatic immunity principle continued to be limited to issues where the state in question in the host country or the embassy started to do commercial trading with other countries. So if they have commercial trading, like buying from vendors or selling to third parties, you cannot have diplomatic immunity if you breach the contract. So then the diplomatic immunity principle started to be cut down again. You cannot use diplomatic immunity if you breach a contract. How can you, just because you're a diplomat, you cheat people's money using fraud, you can hide behind diplomatic immunity? There's no logic. Then it started to be cut down again in cases in England, in cases in Europe, where it applies to personal contracts of employment, where you are a domestic helper, where you are working in the embassy or in the home of the diplomat. You cannot breach that contract. If you breach that contract, you cannot claim diplomatic immunity. So this is where this area of contract of employment is now the contested issue in this case and in a few other cases, and in the case that I mentioned against the Australian embassy. What happened was, after we won in the High Court, we had a mandamus for the Labour Department to do the mediation, and there was a satisfactory settlement between the Australian embassy and our client. So unfortunately, while we have made so many submissions and we have written so much, we actually asked the judge and implored the judge, can you please write a judgment? Unfortunately, there's no judgment for guidance. Because as Aru said, when it came out on the headlines, everybody or many lawyers were calling us, where's the judgment, where's the judgment? We could only give them our submissions. And I'm glad a lot of the submissions that we use are used in Subramaniam's case. Why I say that? Because this principle of diplomatic sovereign absolute immunity in Malaysia, in my view, our view, and our client's view when we argued the Australian case, has now been limited in Malaysia to a restrictive or restricted immunity position. And that must mean it includes these contract of employments, it includes normal local Malaysian law that applies to all Malaysians, whether you are employed by the embassy or not. Otherwise, you have unfairness. What is more pressing is there needs to be a new express law. So the law is, what I mentioned just now, is common law. The judges can develop the law. As I said, it needs to be limited. It cannot be unfair. It cannot be unequal. But what I am saying is that Parliament needs to come in very quickly and be very clear what Malaysia's position is by amending our law on diplomatic relations to exclude certain parts of these very clearly, these matters which clearly must fall within the ambit of our courts, so that these disputes do not arise anymore, because it's very unfair for the poor worker. What I'm saying also is that what is happening now, every day, until today, where Malaysians are employed by embassies, actually amounts to a fraud on the workers, our Malaysians who are being employed by embassies. Why I say that? Because you do not expect our workers, our employees who are going to be employed and they see a job with the embassies to look through the law and the diplomatic immunity provisions and say, oh, is my contract of employment under or not under? You cannot expect security guards. Our one was Karen Chu was a secretary. You cannot expect domestic helpers, for example, to try and understand the law and say, oh, okay, should I enter into this contract now? Because if there's a dismissal, I have no other remedy. Alternatively, are the embassies telling them that? Because I don't think I've seen any contract of employment where the embassy's contract says you have no right to claim unfair dismissal under Malaysian law. In fact, the handbook in some of the embassies say that the local law applies to the full effect. And in this case, what was interesting is the US Embassy actually sued in the Malaysian court. In the Karen Chu case, our client sued the Australian Embassy in the Malaysian court. So there was submission of jurisdiction in the US case, because if not, the US would have said, okay, I'm going to take you, because the only place is the American courts. If you are saying that Subramaniam's case does not fall under Malaysian law, then you must take Subramaniam's case, the embassy must take Subramaniam's case to the American court. There's only two places. But if the US Embassy chooses our Malaysian court, they must fight according to our Malaysian law. So as Aru said, there is no win yet. You only have a situation where the matter is now going to be referred, mediated, or heard. The point is, yeah, of course, there's a federal court leave application that is coming up. But the point is that if this matter can be settled without actually going to a full hearing, is best. But also that Malaysian Parliament, our Ministry of Foreign Affairs, should look at this situation, which actually covers all the workers, all the Malaysian workers employed by the embassies. It's very unfair. I keep saying that, not from a lawyer's perspective anymore, but it's very unfair. You don't expect Malaysian going, and whoever is watching this, if you're working for an embassy, you actually will face this same situation. If something happens to you, you will have no recourse to having the matter heard by the labour court. Something which our law totally provides. Your contract of employment doesn't even exclude the labour courts. And so I'm saying that this is a very unfair situation that needs to be remedied. Thank you.
Okay. Alright. Terima kasih saudara Edmund. Okey, para hadirin sekalian, kita boleh tahu sekarang betapa dalamnya dan betapa kompleksnya situasi Encik Subramaniam dan apa yang dihadapi oleh bukan sahaja Encik Subramaniam, tapi semua pekerja-pekerja di bawah embassy international. Dan kita boleh tahu ada limitasi dan masalah dalam hak case abuse for diplomats as well. So right now, thank you for telling us the reality of what's happening with the laws and the practice around it and the limitations that it poses to our own people. So soalan seterusnya saya akan tunjukkan kepada saudara Arul, dan ini merupakan soalan yang paling ketara lah sekali. Kenapa kes Encik Subramaniam memakan selama lebih daripada 10 tahun? Apa yang istimewa sangat pasal ini? Kepada para hadirin yang tidak tahu apa-apa mengenai kes macam ni, silakan saudara.
Okey, sebenarnya tadi saya mengatakan proses dia melalui lah. Tapi kalau kita tengok dalam kes macam ini, satu saya lihat US Embassy ni, kerajaan Amerika ni, dia tak nak kalah lah. That means they don't want to lose ego. Bagi saya, it's a very simple case di mana kalau pekerja itu adalah pekerja yang teruk, tak selalu tak masuk kerja dan sebagainya, ada undang-undang dengan jelas boleh ambil tindakan suspend dia, buat domestic inquiry dan boleh membuang pekerja itu. Tapi di sini ya, saya ingat di Amerika pun tidak ada undang-undang macam ini. Di Amerika pun pekerja akan ada sistem pembelaan dia, you know. So saya nampak dia macam dia membuli pekerja lah. You see, this pekerja Subramaniam, EPF dia dibayar EPF, dia dibayar sokso. Ini kan undang-undang Malaysia. Mengapa Amerika nak bayar dia EPF dan sokso? Mengapa nak ikut undang-undang Malaysia? Tapi bila pekerja ini dibuang, dia cakap undang-undang Malaysia tidak boleh mengadili kes ini. So bagi saya, mengapa 10 tahun ini ya, satu adalah first thing saya ingat bila kes ini dirujuk kepada industrial court. Industrial court ini menghadapi dilema. Dia tidak tahu dia ada immunity atau tidak ada immunity. Bagi kami merasakan dia first thing sebagai orang biasa, first thing comes to my mind, Subramaniam is not an American citizen. Kalau dia orang Amerika working in the embassy, maybe there is some immunity lah, diplomat immunity, I can understand, no? American protect dia punya citizen daripada disalahgunakan. Tapi Subramaniam is a Malaysian citizen. Dia warga negara Malaysia. And dia undang-undang semua dia guna undang-undang Malaysia, no? Undang-undang Akta Pekerjaan semua they follow the Malaysian law. Okay? That means they couldn't break the Malaysian law. That means kalau Malaysian law cakap kena bagi 20 hari cuti, dia kena bagi 20 hari cuti. Dia tak boleh bagi 18 hari cuti. So in dalam keadaan itu, saya tidak tahu mengapa the industrial court ambil Jabatan Perhubungan Perusahaan ambil masa yang begitu lama lah. Then of course birokrasi lah, antara industrial relation, foreign affairs, dia cakap wow, kalau US embassy, we must go through the protocol department. And now the protocol department involved, and then selepas itu kami frustrate mengatakan file ada di Washington DC. So imagine lah, a security guard tidak dibayar, file dia di Washington. But even that, we gave them all the information, Saya sangat confident, macam saudara Edmund, if there's a discussion, we could have settled the matter. Pasal sudah 10 tahun dah. Subramaniam pun now working, they pandu Grab and all that, is already out. 10 years already. Tetapi, mereka langsung tidak mau buat apa-apa. Sehingga kami kena bawa isu ini kepada tiga menteri lah. This was the finally, we started this case masa Subramaniam jadi menteri. Lepas tu Richard Ryan jadi menteri. Lepas tu Kula jadi menteri. 3 orang menteri, And Edmund Bon punya case Australian Embassy banyak membantu because for the first time, walaupun kita hanya gunakan New Straits Times punya gambar itu, memberi confidence kepada kerajaan Malaysia bahawa mereka kena ikut undang-undang kita lah. Bagi saya, kedaulatan negara kita tercabar kalau warga negara kita tidak ada perlindungan dalam negara kita. There's no protection. Kalau macam itu, what we should say is all Malaysian workers, no one should work in embassy lah because there's no protection. Dia boleh buang you 24 jam. Dia boleh buat apa-apa terhadap you. Mungkin dia boleh tampar kamu. Tapi kamu tak boleh buat apa-apa because there is no, you cannot take them to court. So saya ingat proses itu mengambil masa 10 tahun lah. And belum berakhir lagi. Saya baru-baru pada bulan 6 Mac, saya tulis surat kepada Presiden Joe Biden, Presiden Amerika. Also, we send a letter to the embassy here. We tell them, please stop it lah. Mengapa? Pasal Amerika mengatakan diri mereka sebagai the exemplary country for the world, to follow dari segi demokrasi ke apa. Dia cakap, the America is the exemplary for freedom, Tetapi on labor standards, we want the new US president to look into this lah, Ini long shot lah, tapi ini satu cubaan.
Kita pernah hantar surat macam ni sebelum ni, atau tidak?
Tidak, saya ingat sebelum ini mungkin kita membantah lah they go to war and all that. But this is the first time, a simple case of a security guard. And ini security guard ini 21 tahun dia kerja di embassy itu, It's not like a temporary worker, And 21 tahun berartinya dia seorang pekerja yang mempunyai rekod yang baik. Kalau tidak, takkan dia kerja 21 tahun. In an embassy, in the US embassy lagi, And hari itu dia sakit, bila dia ceritakan benda itu, saya sangat sedih. Dia cakap hari itu hujan. He was having fever. Went to clinic. Sebenarnya MC letter itu dia tak perlu bagi pada embassy tau. He can just tell them. But dalam hujan itu, dia dalam motosikal dia bawa surat itu bagi kepada guard house di embassy. The supervisor cakap, please go home, take a rest. Berehat dia cakap. But he didn't know dia kena berehat sampai begitu lama. You know, so the MC letter, they didn't accept an MC letter. You know, they just sacked him, you know, like that. Yeah. I think that is why, satu lagi sebab saya ingat, kalau kes ini betul-betul pergi ke mahkamah industri ke mana-mana, akan membongkarkan bahawa tidak ada apa-apa lah. If not, if they had very serious issue, dia macam dia curi benda dalam embassy ke, atau you know, they did something teruk, dia keluarkan secret embassy ke apa-apa, I'm sure mereka boleh buang dia 24 jam tanpa sebab. Dia ada very strong, even cannot lah, but they will still can argue. But this case, until today, tidak ada langsung satu pun defense yang mereka keluarkan.
Okay, alright. Okay, kepada para hadirin sekalian boleh tahulah dari feedback Arul kita boleh tahu macam this is a power play. Ya nak daripada perkataan Arul sendiri yang macam dibuli lah juga, dan sebagai saya macam orang biasa, saya rasakan memang ini memang sistem birokrasi lah yang kita selalu nampak dalam mana-mana syarikat pun. Dan sepatutnya soalan seterusnya saya ditujukan kepada saudara Edmund mengenai artikel 31 di bawah undang-undang keistimewaan diplomatik. Tapi saya rasa saudara sudah covered that a lot. You talked about the limitations and the problems and how the diplomatic immunity is cut down slowly, right, year by year. Jadi mungkin saya akan tukarkan soalan ni lah kepada macam
Mahira, I just tanya Edmund benda yang sama tadi. Sama ada Malaysian citizen, are they protected under diplomatic for in this case, you know? Because I still trying to understand sama ada boleh ke? Technically, when you work in the embassy, perlukah you menjadi seorang warga negara Amerika to get that immunity?
Yeah, there's no immunity for Malaysian citizens. Tidak terdapat apa kekebalan. Kekebalan di bawah undang-undang Malaysia dan juga convention adalah untuk diplomat dan pekerja-pekerjanya yang diklasifikasikan oleh negara. Jadi bukan semua warga negara Amerika atau Australia yang bekerja di kedutaan juga mempunyai kekebalan. But normally it's a very wide range of workers. But the immunity actually only applies to the top layer of citizens of foreigners. So it definitely does not apply to Malaysians. Okay, and I want to say about this, it's time for specifically Ministry of Foreign Affairs, when they allow and they regulate foreign embassies on our soil, they can actually impose conditions. And one of the conditions I suspect is being imposed also is that you must hire a certain amount of locally employed staff. That is to ensure that there's jobs for us also, which is good. But we can also impose a condition that there needs to be an agreed grievance procedure. It may be the same, it may be slightly different, but there must be a grievance procedure mechanism for Malaysians or locally employed staff with embassies to air their grouses if they are unlawfully treated.
This goes actually to my additional question. Sebab sekarang kita sebagai saya macam penonton biasa, saya ingin tahu apa what can the maybe any party, foreign minister or the US embassy, how can they be held accountable because they have avoided this case for more than 10 years without a solid reason. How will Mr. Subramaniam be defended like any penalty that they will be imposed on? How can what's the takeaway for Mr. Subra? What can he receive from this, since he is the victim of this situation?
When you are unlawfully dismissed, you file the complaint. First, there's mediation. If the mediation fails, the court, if they find that there's no just cause to sack you, will consider whether it is proper to send you back to that work and reinstate you. In normal circumstances, the relationship with the employer is so bad that it is not proper to reinstate you. Then the worker will only get a certain amount of back wages. So it's damages. That's the worst it can get for the employer, the embassy. But as I think we all know, it is an issue of face as well. It's an issue of floodgates, because if this happens, and we never know, there may have been a lot of people before Subramaniam that have been treated unfairly by any embassy, but because they think that there is sovereign immunity and it's against a state, they may have just walked off silently. So there may have been silent victims of this type of treatment. But now when there's more awareness about this, one, I think survivors and victims actually can come up. Two, there needs to be pressure on government to change the law. And three, one of the non-violent direct action type of ways is to be very careful, even as you take on a lucrative job in the embassy, that you know that one day you will not have your rights. So perhaps, this is not my suggestion, but definitely Aru would be interested in boycotting getting all the locally employed staff, all Malaysians, to boycott taking up jobs with the embassies.
But so for the existing workers for other embassies, macam mana mereka nak dapat lindungkan diri sendiri yang kepada sesiapa yang kini masih bekerja dengan embassy-embassy tertentu?
Mahira, I mean, terima kasih, because actually we were thinking about it, satu daripada di UK, they have made a regulation yang seperti yang Edmund cakap tadi. They made a regulation dalam undang-undang itu untuk protect pekerja-pekerja yang bekerja di embassy lah. Kami nak usulkan benda yang sama kepada kerajaan kita. Sebenarnya kami ada bawa isu ni kepada Menteri Sumber Manusia, okay, yang dulu dan sekarang, dan mereka cakap mereka akan study benda inilah. Because dalam kes ini bukan saja kami yang defendant tau. Kementerian Sumber Manusia juga defendant, because they don't recognize our industrial court. So the kerajaan Malaysia juga melawan US Embassy, So kita mengatakan kepada kerajaan kita, kalau kamu tak boleh membela hak pekerja kita, you must make sure you have the law lah. If there's no law, then keluarkan satu circular cakap Malaysian citizen cannot work in the embassy. Because bagi macam alert kan, macam COVID kita cakap jangan pergi ke sana, keep a distance. So keep a distance from the embassy because we cannot protect you, because I think ini perkara yang agak serious lah, dekat sangat ada, I think about close to 50,000 workers all over the embassies, different workers all over. So this affects a lot of workers actually. So the thing is, they have to respect, saya faham, on diplomatic immunity, that means you are protected in the embassy, that is for benda-benda yang different issues, but not dalam issue macam ini, and this is dalam argument kita cakap this security guard, apa tugas dia, apa tugas Subramaniam? His is a normal security guard. He patrols the place. He takes care of the gates. He sits. He's not holding any specific secret documents of the embassy, working with the ambassador or nothing like that lah. So bagi kami, the Malaysian government kena buat satu regulation seperti yang Edmund cakap, must make a law. And then if if they cannot do the law, then they must be sincere dan beritahu kepada semua pekerja, we cannot protect your interest. No use having kementerian perhubungan perusahaan kerana dia tak ada power untuk touch this embassies.
Okay, alright. So, okay, kita dapat tahu ini yang apa yang kerajaan kita terpaksa buat. Tapi sebagai manusia yang biasa, sebagai rakyat yang menyokong Encik Subramaniam dengan dia punya struggle sekarang, apa yang kami sebagai manusia rakyat biasa boleh bantu dalam kes-kes tertentu macam ni? This is open for both of you.
Edmund, you want me to go? You want to go first?
Yeah, go ahead.
Okay. I think for one is we have to highlight this issue lah. And even PSM, we are thinking of highlighting this issue kepada some of the trade union groups in America, US, to actually raise this issue there, because they need to know that their government berlaku tidak adil kepada seorang lagi pekerja. Saya dulu ingat, when Genting, Malaysian Genting, wanted to open a hotel in America, the trade union from America came to Malaysia. They want to say how Genting treat the Malaysian worker. So I think if they got, so the trade union movement di Amerika pun sangat kena ambil interest how their government treating our workers lah. And I think ini satu case yang bagus untuk menunjukkan. So sangat kepada orang ramai, mereka boleh actually setiap kali mereka boleh tweet, mereka boleh guna social media dan mengatakan bantahan mereka kepada US Embassy. Kerana US adalah polis dunia kan. Tapi kalau polis dunia sendiri membuat kesalahan, saya ingat rakyat kena tegur lah. Why can't you just settle this issue, So kita mendesak orang ramai kalau boleh. The embassy have they call it a chat, embassy chat, di mana people can go in and chat with them. Of course, ramai orang tanya tentang how to get visa to US. But I think they should also ask simple question like, mengapa? Why don't you face the worker, or why don't you bagi pekerja ini hak untuk didengar di mahkamah? Give him a day in court, Sesangat ini adalah beberapa perkara yang kita boleh buat selain daripada undang-undang itu. Membuat undang-undang di parlimen. Kita tidak tahu bila parlimen kita nak buka balik, tapi this is something laws can be made lah, Yeah.
Okay, saudara.
To understand the argument for the embassy is also important, and how the High Court decided. It's very technical, but I simplify it. And in Subramaniam's case, as Aru mentioned, the government, there was an appeal by the US Embassy against the government and also Subramaniam. In the Karen True case that we did, we had to sue the Malaysian government because the Malaysian government refused to refer the matter, as the Malaysian government had decided already before hearing the case that there was sovereign immunity of the Australian embassy. What the High Court decided is that the High Court said the case law says, look at what is the function of the particular job. If the function of the particular job is an extension of the act of sovereignty of America, so if Subramaniam was by extension, because he was looking after the security of the embassy, also doing part and parcel of the what is called the sovereign functions of the embassy, or the sovereign functions, means what he was doing is an extension of the sovereign functions of the United States of America. So the court said, because what he was doing was to protect the embassy, it was part of the sovereign functions of the United States of America. And therefore, because it was part of the sovereign functions of the United States of America, then there was diplomatic immunity means it is an act of America. When it's an act of America, whatever that America does is immunized, means nothing can be, and I think nothing that America does can be challenged. So that, I think, is the debate now that may go to the federal court, because the Court of Appeal said, look, let us go back to the Labour Court and Industrial Court and decide whether what he was doing was part of the sovereign function of the United States of America or not. And I think that's an opportunity to argue that there is a difference between sovereign acts. For example, if America enters into a contract with Malaysia to provide vaccines, for example, is that a sovereign act? So is that a sovereign act that if America says, I promise to give you how many vaccines, but I don't give it to you, can America sue? Can America be sued by Malaysia? Or is that part of immunity? For me, it's very clear. If it's contractual, even if it's to buy submarines or arms, it's contractual. You go to find the arbitration or court and settle that matter. There cannot be immunity. If there is an issue of employment like this case, it's only the employee and the employer, whether the employer was unfairly dismissed. That shouldn't be immunized as well. If there's sexual harassment of a domestic helper by, for example, a diplomat in the home or in the embassy, you cannot say that that is immunized by diplomatic immunity. So I don't see any difference for a contract of employment having diplomatic immunity, especially when it comes to our own citizens.
Okay, alright. Okay, para hadirin sekalian, kita dah masuk sesi, kita dah masuk minit ke-53 untuk sesi ni. So far, saya boleh safely say that kita dah cover almost all angles of this case. Dan sangat, tak silap saya, kita tak ada soalan pun dari para hadirin. Jadi, saya boleh announce lah, this is the end. Tamatlah kita punya sesi bicara pekerja kita pada malam ini. Sekali lagi saya ingin berterima kasih kepada tetamu jemputan kita, Saudara Arul dan Saudara Edmund, dan juga terima kasih kepada semua kerana sudi meluangkan masa untuk menonton sesi kita malam ini. Jangan lupa untuk like, follow dan share video ini. Follow page PSM kita untuk dapatkan news-news terbaru untuk mempelajari tentang kes-kes hak kemanusiaan di Malaysia. Dan jangan lupa untuk share ini untuk jaringan kawan-kawan anda di Facebook. Nama saya Mahira. Assalamualaikum, selamat petang dan salam perjuangan. Terima kasih.
Terima kasih.
Thank you.
Thank you.